start talking about what we're selling real estate, right? When we get out of this class, our goal is to sell real estate, right? So we want to figure out what makes something in the state and what makes it real. Like, what are we really selling when we get out of this class? All right? So we're going to highlight the paragraph at the top of the page, on page 1, under chapter 1. You're going to highlight that paragraph at the top of the page, and then you're going to highlight Roman numeral 1, which looks like an I, for those who don't know the Roman numerals. You're going to highlight the whole paragraph at the top of the page, and you're going to highlight Roman numeral 1, and then you're going to highlight capital A, and then you're going to highlight 1 and 2 underneath that. You're going to skip the example, and then you're highlighting capital B all the way down to the bottom of the page. That's how I'm going to tell you, okay? And now you're going to put a star at property at the top of the first paragraph where it says property. We're going to put a star by that. Property is the rights or interest which the owner has in the thing owned. It's a bundle of rights. It's the right to possess, use, encumber, dispose of, and to exclude. Property can be real or personal, which they call chattel. I always think of chattel. Chattel is personal property. Chattel sounds like cattle because it's movable. Alright? You're going to remember that. Chattel sounds like cattle because it's movable. Real property is immovable by law. Right? It's the rights or interests you have in the thing owned. If you really think about it, can you take it with you? You own this piece of land. What can you do with it? You can't move it anywhere, right? It's your right to use it, the right to possess it, the right to will it to your family when you die, the right to build on it to a certain degree, right, based on laws and stuff. That's what it is. So real property is the rights or interests you have in the thing owned. Does that make sense? Property can be real or personal, which is chattel. The ownership interest a person has in the land is called an estate. So your ownership interest is an estate, right? The word estate expresses the degree, quantity, nature, duration, or extent of an interest in land. So there's two types of estates. There's the fee or freehold estate, which means I own it, right? And then there's the less than freehold estate or a leasehold estate, which is what? When you rent it, right? They're both estates and real property. One, you own it. You can do what you want with it. But the other one, it's the right to possess it. It's the right to use it. But you don't own it. You can't actually sell it or will it or anything like that, right? So there's two different types of estates. A freehold estate, put a star by letter, Roman numeral 1. An estate that endures for a period which is not fixed or ascertained by a specified limit of time, characteristic of the holding of a free man under the feudal system. It can be a fee estate or a life estate. Put a star by A, fee or fee simple. The greatest interest a person can have in land. That idea, guys, is on the test. What's an estate? What's a fee estate? The greatest interest you can have in land. It is of indefinite duration. Why is that? We don't know when we're going to kick the bucket, right? When you own something, you don't know when you're going to die. So it's of indefinite duration. It's freely transferable. It can be disposed of during your life or upon death, right? It's also referred to of estate and inheritance. Once again, that's related to the fact that you don't know when you're going to die, right? So when someone inherits that estate. Or a perpetual estate. There are two types of fee simple estates. There's the fee simple absolute, which means you hold it without any qualifications or limitations. Now I'm going to tell you this, guys. Every property has qualifications and limitations, right? They're called encumbrances. Can you do whatever you want with your piece of land? Like, if I own this piece of land, can I, decide I'm going to sell heroin from it and that's okay because I just want to? No, right? There's rules saying, no, you can't really do that on land. In fact, if you do that, the DEA can come and seize your property, right? Okay, so we can't do anything we want. Can we dig for gold and mine gold on our property? Well, not really in the state of California. I mean, for all intents and purposes, we do have the rights to the minerals within our land, but the state reserves those rights, right? If we buy a piece of land, that's like in a residential neighborhood, can we put a muffler shop there? No, right? Because there's a rule against that, right? So very few properties come with zero encumbrances, or you can do whatever you want on it, okay? But that's the definition of the fee simple absolute. The fee simple defeatable, defeasible, put a star by it. The owner holds it subject to special conditions or limitations, and if they're breached, the title goes back to the original owner or heirs. The title is defeated. The example that they give, and this is very similar to the example they tend to give on the test, so we're going to read it, right? In 1935, the McDonald's conveyed title to a parcel of land to Archer and specified in the deed that the property shall never be used for the sale of intoxicating beverages. And if this condition is breached, the title would revert to the original grantors. This limitation applies to Archer and all subsequent owners, and if there is a violation of the condition, the McDonald's or their heirs have the right to terminate the estate and retake the property. The title can be defeated. So I want you to write this down above the example. Fee simple to feasible equals no drinking alcohol. Fee simple to feasible equals no alcohol. Means the title can be defeated. That's almost always the example on the test, okay? A life estate is an estate that is held limited in duration to the life of its owner or to the life or lives of one or more designated persons. The holder of the life estate has the right of possession, has the right to all rents and profits, is duty bound to keep improvements repaired, and must pay taxes in just proportion of assessments. Write this down at the bottom. A life estate, at the very bottom, you highlighted B, capital B, all the way down to the bottom of the page, should have been highlighted. A life estate equals reverts back to original owner. So let me give you guys an example. Well, you're like, what's a life estate? What does that mean, right? So back in the day, has everybody heard of a reverse mortgage? Yeah. Okay, a reverse mortgage kind of takes care of the elderly people today, the elderly population, right? When they own their home, but they don't make enough money, right? They can actually get the bank to pay them money to live on while they're alive, and then their mortgage goes up every month, and it's paid off upon their death. Okay? That's a reverse mortgage. It's where the mortgage company pays the owner and they add it into the mortgage because there's equity in the house. Okay? Well, back in the day, they didn't have that, right? So an elderly person might say, Morrow, will you buy my property? I'll sell it to you today, but this is the deal. I get to live in it till I die. It's my estate till I die. You're like, wow, I'm getting a great price on this house. I'm going to let these old people live. But now they get cash to live out the rest of their life until they die, and then Morrow owns the property. All right? So that was how a life estate used to work. Okay? Sometimes you can have a life estate based on somebody else's life. Because let's say you were married, Morrow. I'm going to marry you off. What's your name? Amanda. Amanda's really cute. Morrow and Amanda got married. Signature tree, K-I-S. Oh, okay, wait. So, but then something horrible happened. Amanda cheated on him. Dun, 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 right? She cheated on, what's your name?
Arvin.
Arvin? She's like, yeah, I like Arvin. Right? Poor Amanda cheated on Morrow, and he had to break up with her. It's like, oh my gosh, And they had a kid together. And he's rich, and he's like, okay, listen, this is the deal. I'm going to leave you the life estate based on your life or the life of our child, right? As long as our kid's alive, he gets to stay at home with his mom. But once that's done, once the kid moves out, then I want my estate back. Does that make sense? So that would be a different way. So in that case, Amanda would have a life estate based on their kid's life, right? Or until the kid moved out, and then it would revert back tomorrow. Ah, that's funny. Tomorrow. This is how we break out in song and get off track, guys. I'm telling you right now. All right, page 2. So we're still talking about a life estate. At the top of the page, I want you to highlight 5, 6, and 7. CD. 2 in the example. And then Roman numeral 2 all the way down to the bottom of the page. So they must pay any interest on any encumbrance, put a star by 6. They may sell, lease, or encumber the property only for the duration of the life estate.
Star by 6?
Yeah. A termination of the life estate would void any sale, lease, or encumbrance. So, Amanda, let's say your kid's still alive, but you can't stand the house, right? So you decide, what I'm going to do? I'm going to rent out this house. So what's your name?
Jasmine.
Jasmine. You're going to rent the house out to Jasmine, okay? Because your kid's still alive, so it's still in your life estate. You're going to rent it out to Jasmine and you're gonna get the same amount of rent there where you could pay someplace else and just have fresh memories, because, you're moving in with Arvin, right? So, but then something horrible happens to your son. Oh my gosh, bad accident or whatever. Now he dies and that estate is no longer yours. It's supposed to go back tomorrow. What happens to Jasmine's lease? It's over. She doesn't have any rights to the property because it was based on the life of your son. Does that make sense? So then, even if you signed an agreement, you're SOL.
Yeah.
Do you know what that stands for? See, I didn't have to say it. Yay! That's what I'm going to do. I'm going to try not to swear and let you guys swear for me, and then it won't be like, the teacher swears. That would be cool. Yeah, these are ruthless, reckless children in this class. All right. So, they can sell, lease, or encumber, but only for the duration of the life estate. That idea has a star by it, number 6, and that idea is on the test, or maybe on your test. They cannot commit waste. While she's got the property, she can't trash it, okay? Put stars on C and D. An estate in reversion, if title is going to return to the original grantor, like in the example we had, following the death of the designated person on whose the life estate depends, the grantor holds an estate in reversion. Just like on a lease, when somebody leases their property to a tenant, right, the landlord has an estate in reversion. In other words, when the tenant is done living in the property, the landlord gets possession of the property back, right? That's an estate in reversion. It's just a different kind of estate in reversion. Then there's the estate in remainder. Put a star by that one. If the title to the property is to pass to a third person upon the death of the designated person on whose the life estate depends, the third person holds an estate in remainder. Those are definitions you need to know for your test. The example, Archer deeds the property to Baker with the provision that Baker is going to own the property while Celia is living. Upon Celia's death, title is going to revert to Archer or his heirs. Baker holds a life estate based on the life of Celia. Archer holds the estate in reversion, and Celia holds no estate, but is the party on whose the life estate is based. Okay? That's how a question might be worded on the test. They're going to say, what kind of estate does Celia have? And they're she doesn't have one, right? Answer D, none of the above. A less than freehold estate, you already highlighted it. It's an estate owned by a tenant who rents or leases the property, commonly called a lease or a leasehold. The leasehold features, put a star by 1, 2, and 3. The lessor is the landlord who holds title or reversion during the lease. The lessee is the tenant who holds the right to exclusive possession. And the leasehold is the chattel real. Chattel, right? That's personal property because it's movable, right? But it's an interest in real property. It's an interest in real property, but still only a form of personal property. And the tenancy is the estate of the tenant holding a property of another. These are definitions, basic definitions you need to know for your test. But I want to talk to you about something because we talked about the lessor and the lessee. We're going to talk about the ors and the e's in real estate. The ors and the give-ors. I know it sounds weird, but just think of it that way. The give-ors of whatever. So the lessor is the give-or of the lease. Okay? The lessee is the receiver of the lease. The grantor is the give-or of the grantee. The grantee is the receiver of the grantee. Right? The trustor is the giver of the trustee. The trustee is the receiver of the trustee. So you always remember, the offeror in an offer, the offeror is the giver of the offer. The offeree is the receiver of the offer. So the ors and the e's, that's how you remember who's the giver and the receiver. Okay? So the lessor is the giver of the lease. The lessee is the receiver of the lease. The leasehold is the interest that the lessee has. And the tenancy is the estate of the tenant holding the property of another. On 3, you're going to highlight the whole page. Types of leasehold estates. There's 4 types based on the length of their duration. Put a star by number 1. This is the tricky one. There's always going to be tricky stuff in real estate. Just they're always going to try to confuse you with tricky things, okay? So, the estate for years, put a star by it. It's one which is to continue for a definite period that has been fixed in advance. It can be a period measured in days, weeks, months, or years. On the state exam, they may ask a question like this. somebody owns a leasehold estate, right, from May 23rd, 2016 to August 26th, 2016, what kind of estate do they have? And you know what the answer is going to be? Huh? An estate for years, right? It has a definite start date and a definite end date, and it's part of a year, okay? An estate for years is start date and end date. It can be measured in days, weeks, months, and years, okay? An estate from period to period. That's like month to month, week to week. That would be considered an estate from period to period. So I kind of want you to think about the clock or the calendar or the cycle of the moon or whatever you want to call it, right? Haha, I kind of made a little bit of joke right there. I didn't realize it. A tenancy at will. This is one where both people have the right to cancel. This is like kind of when your deadbeat boyfriend kind of loses his job. Who's been in that position, right? Your boyfriend loses his job and he doesn't have a place to stay and he's kind of like on the verge of living in his car and you're like, all right, you can stay on my couch, you know, and then he stays on his couch and he wears his robe all day and he's barefoot and he's got the remote in his hand, right? Has anybody had that? I had that. He's going to be an actor. I was like, dude, like no one's going to come to the condo and knock on the door and offer you an acting job while you're wearing your robe and your bare feet. You know, like, I'm sorry, like I just don't see it happening. So that's a tenancy at will. As long as he doesn't pay rent and you don't accept any rent, right? You don't have a deal. He can leave when he wants and you can kick him to the curb when you want. Okay, that's a tenancy at will. Then there's the state of sufferance. That's like when the landlord wants you out, Arvin, because you stopped paying your rent. But you're staying anyways, and the landlord's suffering. You're like, oh my God, right? That's an estate of suffering. So that's how you remember the 4 different types of estates. Leasehold estates, right? So estate for years is what? Days, weeks, months, and years, right? Period to period, month to month, week to week, based on a calendar, right? Tenancy at will, deadbeat boyfriend, right? Estate of sufferance, oh my God, the landlord is suffering. Okay, those are easy ways to remember it.
I like it.
He likes it. Arvin's all in, man. He's like, yeah, this is good stuff. The requisites to create a leasehold. No particular language is required as long as there appears to be an intent to lease and a mutual assent. Terms, however, have to include the names of the parties, the description of the premises, the amount of rental payments, and the time and method of payment, and the length of the lease. If it's a city, urban, or rural property, it's limited to 99 years, and agricultural land is limited to 51 years. Does anybody wonder, like, why would somebody have a 99-year lease? Or you do? You know why?
No, I said I wonder why.
You do wonder why? Look at you. See, the only one who's really honest in this whole class. What's your name?
Jason.
I'm going to call you Honest Jason. Honest Jason. You know the answer?
Maybe.
What?
Because of like family farms that keep going on and they live there.
Family farms is one idea. Did you guys realize that off of Bouquet Canyon, some of those cottages are built in the Angeles National Forest? Did you ever think about that? Who owns that land? The Angeles National Forest owns the land.
That's like a no-brainer. That was like so easy.
Right? So what happens is when people buy those cottages, they buy the cottage, right? But they lease the land. So it's hard to get a loan on it because, you know, they don't really own the land, but they do sign like a 99-year lease. So that way it's not just in their family, like they can will it and all that stuff. Does that make sense? And they pay like I'd say like it's like $1 a year or $100 a year. It's like almost nothing for their, right, for their land rent because they live in the National Forest. Does that make sense? Okay. If the length, on number 5, put a star. If the length is for more than a year, it has to be in writing. I'm going to tell you a little secret here, guys. Almost anything, if it's going to take more than a year, based on the statute of frauds, if it's going to take more than a year, it has to be in writing. Okay, that's an idea. That's on the test. If it's more than a year, it's in writing. Okay. If it's in writing, it has to be signed by the lessor. Isn't that weird? I think that's so weird. So I create a lease. I own property, right? I'm going to rent it out to Jasmine, and I have to sign it. Don't you think Jasmine should have to sign it? In real estate, in real life, right, we always sign and have everybody sign everything, right? But for the test purposes, the lessor has to sign it. It's like, well, that's kind of weird. The lessee usually signs, but acceptance of the lease terms is the same as signature. Well, how would Jasmine accept my lease terms?
Take the keys.
Huh?
Take the keys.
Take the keys. What else?
Move in.
Move in. Pay me.
Rent.
Pay rent. That's acceptance of lease terms, guys. Right? She pays me the rent. She accepted the lease. She doesn't need to sign it. To record it must be acknowledged by the lessor before a notary. Put a star by that. Note the words let and demise are not necessary. Lease provisions. The following are the provisions set forth in California law. Rights of possession, put a star by 1. Upon commencement of the lease, the tenant takes over the same rights as held by the landlord with respect to possession and quiet enjoyment of premises unless the landlord reserved rights. What kind of rights do landlords reserve? Don't drink, don't smoke, what do you do?
No pets. They got there. I can tell you no pets.
No pets? No
Yes, no growing
smoking?
marijuana.
No marijuana?
Don't alter.
Jason's like, I can't live there, huh? Don't alter the building? Right? No painting it? No water beds? Right? Those would be provisions. So when a landlord's leasing out their place, right, they're giving the possession of the property to the tenant. Except if they reserve some rights, like you can't put stuff in the shed, or you can't have a water bed, or you can't have pets, or whatever, okay? Rent, consideration. Rent is consideration paid for the use of the property. It's legally payable at termination of successive periods of holding, and most contract terms require payment in advance. On page 4, highlight 3 at the top of the page. Little a, little b. 4. 5, all the way down to the bottom of the page. So when I say 5 all the way down, it's like everything underneath 5. Security deposits, advance payment to cover last month's rent, cleaning or key deposit, damage to premises, or security for performance. On a lease of residential property with a term that's less than 6 months, in addition to the first month's rent, the landlord cannot collect more than the following amounts of security for any reason. Put stars by A and B. The unfurnished property is equivalent to 2 months' rent, and furnished property is equivalent to 3 months' rent. On the margin, write this down. Security deposit depends on if it's furnished or not. Security deposit depends on if it's furnished or not. There may be a test question that says something like, hey, how do you determine what the security deposit's going to be? And the answer is, oh, it's on the length of the lease, or this or that, or, you know, if they're married or not, or how many kids they have. And one of the answers might be, it depends on if it's furnished or not.
Security deposit depends on
If it's furnished or not. Discrimination. Various state and federal laws, thoroughly reviewed in later chapters, prohibit discrimination based on race, religion, ethnic background, sex. I don't understand why they discriminate against having sex. I mean, that's what makes the world go round, and that's what always confuses me. Marital status, physical disability, and in some cases, families with children. So on the margin, you're going to write discrimination. Don't do it. Not Nike, just do it. No, don't do it. The opposite of Nike. Ekin. Right? E-K-I-N. Maintenance and repair. The landlord has a duty to keep residential property in fit condition and to repair dilapidations that render it untenable unless the tenant caused the dilapidations. Effective waterproofing and weather protection of the roof and exterior walls, including unbroken windows and doors. A landlord has to do that. Plumbing and gas facilities have to be maintained in good working order. A water system which produces hot and cold running water has to be there. Heating and facilities maintained in good working order. Building grounds, cleaning of trash, rodents, and vermin. An adequate number of garbage cans and trash barrels kept in clean condition and good repair. And floor areas and railings maintained in good repair. Okay? So as a landlord, there's a lot of responsibilities, right? The landlord has to do a lot of things. And if you don't do those things, the tenant can call code enforcement on you. All right? On page 5, you're highlighting the whole page. Quiet enjoyment and possession. Every lease has an implied covenant whereby the lessor agrees to place the tenant in quiet enjoyment and possession of the property, and the covenant is breached if the landlord enters without consent, unless there's an emergency, makes unnecessary or unwarranted repairs or alterations, harasses the tenant with excessive noise or pestering, locks the tenant out, or cuts off utilities, people, even not permitted even if the tenant is arrears on the rent. I had a property that I was managing for a while, and the tenant literally was running up $600 a month water bills and not paying rent, and we could not turn off the water. And they wouldn't let us in to see what the heck was going on. We think she started doing a laundry business or something, or other people. She was laundry, huh? I don't know what she was doing. Maybe she was growing some odoriferous 5-leaf plants. Okay, the tenant's rights and recourses. If the landlord fails to maintain the property in a habitable condition, and if the breach is serious and material and not due to the tenant's negligence, the tenant has to give a notice, preferably in writing, to the landlord of the defect, and can do any of the following if the defect is not corrected in a reasonable period of time. They can first withhold payment of the rent until the deficiency is corrected. The landlord could attempt legal action for non-payment of rent, but would be unsuccessful if the tenant was justified. They could pay the rent but sue the landlord for failure to make repairs, so they could take him to small claims court. They could report the landlord to the local housing authorities regarding the deficiencies, and then you got code enforcement involved. Or they could abandon the premises, put a star by this one, under the doctrine of constructive eviction. So you need to understand the definition of constructive eviction, okay? And consider the lease canceled. They could make the repairs themselves or hire someone else to do it and deduct the cost from the next month's rent. However, this remedy cannot be used more than 2 times a year, and the repair cannot exceed 1 month's rent. If the landlord retaliates within 180 days by terminating the lease or raising the rent, the termination or increase will not be upheld in the courts. Put a star by F, 1 and 2. Transfer by a lessee. The tenant may assign or sublease the premises when the lease does not prohibit such. Just FYI, all of our California Association of Realtor contracts do not allow assignment of leases, okay? But if somebody wrote up their own little lease, like, oh, they're just going to rent something and they write their handwritten lease or whatever, it probably doesn't mention that, and the tenant could possibly assign the property, okay? Violation of a prohibition merely makes the contract voidable by the lessor. You think, well, geez, shouldn't it be void if they weren't allowed to do it? So if Amanda decided to transfer or assign her lease to Jasmine here, okay, and I didn't know about it, it makes the lease voidable, okay? It's not void. Void means it doesn't have any effect and like it's done. She can't even move into the property or whatever, okay? Voidable means I have the right to cancel it. But let's say, look it, Jasmine's cute. She looks like she has a better job than Amanda. You know, she probably pays her rent on time. You know, she has 16 cats because Maro left her and the kid died. She's like totally screwed. So she became like that cat mom, you know, so the house reeks, right? But Jasmine here, I like her. I'm going to keep the lease. Right? So it's voidable. So you need to understand the difference between void and voidable and why in that situation would happen. That example is not on the text. All right. Assign and put a star by it. Transfer the entire leasehold. That means the assignee takes over the entire premises and unexpired term, and the assignee becomes primarily liable. One of the things you need to know about assignments, especially for like the test, is let's say I had a lease with an option to buy, and then I was going to assign it to Honest Jason over here, right? He gets all the rights that I have with the property, including with the option to buy. So when something assigns something, they're not just giving over like a piece of it, they're giving over all of the rights they had in the property. So if I had the right from the landlord, right, to have a lease with option to buy, and my money was going towards my option to buy, and I assigned that to Jason, he gets all the rights, not just the, like you can live in the property. Does that make sense? All right. Sublease, put a star by it. The transfer of less than the entire leasehold. The subleasee receives only a part of the unexpired term. The sublessee is liable only to the sublessor. The lessee remains primarily liable to the landlord. What's your name? Laura. Oh, you were over here.
Yeah.
You were with my us. All right. So Jason, let's say Jason decides he wants, I'm going to Cancun in September. You guys are going to be so sad because I'm going to be gone. But it's okay, I'll be back, so don't cry. But Jason's like, yeah, I'm gonna go to Cathy to Cancun, right?
You gotta watch out for those mosquitoes.
So he's gonna go to Cancun with me, and he doesn't want to have to worry about that 1 week's worth of rent, right? So he's just gonna sublease the apartment to you for that 1 week. You're gonna pay Jason, Jason's gonna pay me. So, you know, it's a sandwich lease. It's like a little piece in the middle. It's the ham and the
Sandwich lease.
yeah, it's a sandwich. It's I know we're all getting hungry now. I get
Do you have to
it.
get permission from the owner in order?
Well, we were talking about this. This all came under the categories if the contract allows for assignment or sublease. When I said California Association of Realtors contracts don't allow for it, but if somebody just kind of wrote out their own little lease, they may have forgotten to restrict that. Right? That would be something that the landlord would have to say you cannot do. Otherwise, it's assumed they can. Does that make sense?
Yes.
Okay. Termination of the lease. The lease will be terminated by expiration of the agreed term or during the term for the following reasons. Put a star by 1. Written notice. A periodic tenancy, a month to month, requires a 30 days written notice by the landlord or tenant if the tenant resided in the dwelling less than a year. If the tenant resided for more than a year, the landlord has to give a 60 days notice, but the tenant only has to give 30. Okay? So, keep this in mind. We live in a non-rent controlled area. So this is the state law, and in our non-rent controlled area, that is the prevailing thing. So any landlord here in the Palmdale-Lancaster area can kick a tenant out, even if they were there for 12 or 13 years, with a 60 days notice. There's no other recourse, okay? But if you're like in LA City, they have rent control there, right? So that might not work out that way. So you always want to make sure wherever you are, if it's rent controlled or not, because the different laws are going to prevail. And if it's more restrictive, right, meaning the person who owns the property gets to do less with their property than they want to, that's more restrictive, right? The more restrictive thing always prevails. So the state can say, oh yeah, 60 days, 30 days, la 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 la, it's all good. But if you live in a city or an area that has more restrictive rules and regulations, you have to abide by those. Does that make sense? All right. Surrender or abandonment only applies if the tenant abandons and the landlord gives an unqualified acceptance. Tenant Amanda, she didn't sublease out to, or she didn't assign her lease to Jasmine, but she moved out with all of her 25 stinky cats, and I was like, oh, thank God she's out. I was like, okay, she had a year's lease, but I'm really glad to see her go anyways, right? That's a surrender. And by the way, the idea with the surrender is that the tenant is surrendering the property, and the landlord is surrendering the lease. Right? The tenant's surrendering the property, and I'm surrendering the contract. I'm letting her out of her contract. Okay? On 6, highlight the whole page. The breach of covenant of quiet enjoyment and possession is considered to be actual or constructive eviction. Condemnation, if the tenant is released, if the entire property is taken in an eminent domain proceeding. In other words, what's your name, Miss, at the back?
Chelsea.
Chelsea? When Chelsea said, hey, if the train tracks was put in there, right? And let's say the train tracks wanted to come and put their train tracks right in the middle of the backyard of that property, and they came and took the property as an eminent domain proceeding and said, oh, we need this land for our train tracks, right? Of course the lease has to be canceled because they can't live there anymore if they're going to build the train tracks there, right? That's considered condemnation. They're doing that on the 405 freeway by the Sepulveda Pass, right? The MTA came in and took parts of people's backyards, right, on Sepulveda Boulevard to expand the freeway system there. They forced the people to give up part of their backyard. They gave them double pane windows. They gave them, extra, block wall fencing, redid their landscaping, and they probably paid them some money to boot so that they could make that Sepulveda area wider for the on and off ramps over there by the 405 and the Sepulveda Pass. Okay? Commercial frustration, change in zoning law or other regulations makes an intended use unlawful for the tenant. Put stars on 6 and 7. A court action. The tenant has the tenant ousted for non-payment of rent or for breach of contract. This is called an unlawful detainer action. Okay? An unlawful detainer action is the fancy word for eviction, and you need to know that definition for the test. A surrender is a mutual agreement to terminate, and we already talked about that. Defaulting rental payments. If a tenant fails to pay the rent on the due date, the landlord has 3 options. They can, 1, sue for each installment as it becomes due, whether the tenant stays in possession or not. They can retake possession, clean, relet, and sue the former tenant for damages, lost rent, and expenses. They can serve a 3-day notice to pay rent or quit, and if the tenant fails to pay or leave, they can file the unlawful detainer action to have the court evict the tenant. Note, if the landlord who causes the utility services to be cut off, or if the landlord locks the tenant out with the intention of terminating the tenancy, the tenant may sue and recover actual damages up to $100 a day, punitive damages, and attorney's fees. So you can't just kick a tenant out like that. Okay? Types of leases. There's the gross, flat, fixed, or straight lease. This is a lease for a fixed period of time at a set rate of rent. So your normal everyday lease, your month-to-month lease that you pay is considered a gross, flat, fixed, or straight lease. Your normal everyday lease. A graduated lease is a lease which provides a varying rental rate, often based on future determination. Some places have like move-in specials, right, where it's cheaper to move in and then they make it more expensive. Or they might even have one where if you pay your rent on time for, 11 months out of the year, they make it cheaper in December so you have more money for your Christmas presents, right? An escalator clause, put a star by it. It's a clause which provides for an increase or decrease in rent, often based on cost of living index. One of my landlords is selling a property right now, and one of the tenants is her granddaughter, and the lease started at $600 a month, and then the next year moved up to $700, and then the next year moved up to $800. Do you know what I mean? And she had it so that her granddaughter could start out with, like in her little apartment, and then, as she got a little bit more situated, her rents were going to go up. Does that make sense? A sandwich lease is a leasehold interest which lies between the primary lease and the operating lease. It's a position of a sublessor and a sublease. We talked about the sandwich lease. A net lease is a lease which provides the lessor with a fixed income based on an agreement whereby the lessee is going to pay all or some of the variable expenses, right? So sometimes you have somebody move in, and because your utilities are going up or whatever, you're just going to have them cover like the cost of utilities or something like that. That would be the net lease. And then the percentage lease, put a star by this one. This idea may be on your test. It's a lease in which the rental is based on the amount of business done by a lessee, usually a percentage underlying gross receipts. It's a percentage of the gross receipts for a percentage lease. Okay? So we can pretend that this is our restaurant, right? We are renting this space and this is going to be our restaurant. The landlord, because nobody knows about us yet, right? We're probably not going to have that much business on our first few months, right? So what the landlord does is they charge me a percentage, because we know that in any kind of business, right, you spend a certain percentage of your money on your staff and your building and your food expense and your liquor expense, and although mine might be really high because it might be an alcoholic or whatever, but whatever, right? So we have a certain percentage of all these different percentages of what they spend. Well, the landlord said, okay, well, I want you just to pay me whatever the normal percentage you pay for rental expense, right, lease expense on a restaurant. So when I only make $100 today, because it's my first day in my new restaurant, I'm only going to pay them a percentage of the $100 I made, right, to stay within my margins. Because if my business fails, right, that's not good for the landlord either. And what happens is the percentage, as I become more in alignment with what's a proper rental rate for the area, my percentage goes down, or I just go back into a straight lease. Does that make sense? So sometimes a landlord will let you start out like that in a business so that your business doesn't fail right away. 7. Highlight the whole page. So first up, we talked about estates, right? We talked about estates, right? We know there's two kinds of estate. The fee estate means what? I own it, right? The less than freehold estate is also known as a leasehold estate, right? And that's where you just have the possession, right? The fee or freehold estate, there's the estate of inheritance or the perpetual estate, right? Because it's based on, we don't know when we're going to die, right? It's called the estate of inheritance for that reason. You don't know exactly. It's of indefinite duration, right? It's the rights or interests we have in the thing owned, correct? A leasehold estate, we know that we get possession of the property, but we don't own it. We know that there's the estate for years, which is, how do we figure that out?
Fixed date.
Fixed date, start and end date, right? Days, weeks, months, or years. The estate from period to period is what? Month to month, week to week, right? The estate at will? Deadbeat boyfriend, right? The estate at sufferance? Owner's suffering because your tenant didn't move out, right? So we talked about estates, right? So we know when we're selling real estate, we figured out the estate part. And now we're going to talk about what makes property real. Woohoo! Isn't this exciting? All right. You're highlighting the whole page of 7. Put a star by real property. Real property consists of land, anything affixed to it, that which is incidental or appurtenant to it. The word appurtenant means runs with the land. It'll come up many times. And that which is immovable by law. Remember we talked about chattel, which is what? Movable. It's personal property. Chattel sounds like cattle because it's movable, right? Real property is immovable by law. we can't take it anywhere, right? So that's why it's a bundle of rights. It's the rights or interests we have in the thing owned. Land, material of the earth, whether it's soil, rock, or other substances. It includes not only the surface, but everything under it and above it. Did anybody ever see that movie called, Burlesque. Amanda's not as dumb as I thought. This is wonderful. She's blonde, but she's no dummy. Wait, guys, this is what I have to do every class, just so you know. This is my version of refueling, okay? Yes. Okay, so yeah, burlesque. Do you remember burlesque? Okay, does anybody know how the story goes? She owns like a ratty kind of like bar where girls dress sexy and dance sexy and stuff like that, like burlesque shows, right? And they want to like take her land. The developer wants to come and take her land and develop a big condo complex there. And she doesn't want to sell because like this is her family business, this is what she loves, but she breaks up with her husband and half of it's his and she doesn't have the money to buy him out, you know, so she needs to do something. Well, she goes to another condo complex, right, that's a few streets down, that they're selling their condos for a lot of money because of the view. Well, if the new condo place buys her place, what's that view condo going to have? A view of another condo. Right? The new condo will have the view. So what she did is she sold the airspace above her building to this guy here and promised that she wasn't going to let it build up, right? So that his condos got to maintain the view and sell at the higher price for having the view. All right? So when you own land, you own the dirt, but you own what's inside the dirt, right? And you own what's above the dirt, the airspace. That's why you're allowed to have like ham radios in some areas and stuff like that, because you own the airspace as much of it as you can use, right? So airspace is a public highway. Like think of the Sears Tower, right? It's a tall building. People can't just like, you know, hang out there and like do flybys and shake the building, right? Because they own that space, right? It's a public highway, but the landowner owns at least as much of it as he or she can use and occupy in connection with his or her land, and has the right to prevent the use of it by others that would interfere with the use of the land. Lateral and subadjacent support. Lateral support is support from adjoining land. The owner of land below another owner of a hillside lot cannot excavate without proper shoring any part of the hillside lot, which could lead to shifting. So if you show a house and it's got like one of those yards where like the backyard kind of has like a beautiful like landscape that goes up, and the guy's like, yeah, I'm going to build me a man cave right there. Right? And he thinks he's going to go in there with a shovel and pull out some dirt and make like a real cave in his man cave. He won't be able to do that because it could affect a property that was above him, right? And it might make it sink. So you're not allowed to do that, right? Remember how we talked about almost all land comes with like what they call encumbrances. I can't do everything I want to do with it. Well, that's what they have to check it out. They have to get a geological report and see if they could do it or see if there's a way to shore it up. And it could be like a $100,000 treehouse or something, right? Subadjacent support is the support from underlying strata. Oil and minerals can be excavated to the extent which might cause the surface to sink. Land bordering on water, the law applies as follows. Tidal waters are owned to the ordinary high water mark. Navigable lake or river is owned to the edge of the lake or river at the low water mark. And other waters are owned to the middle water mark of lakes, or streams. Unmined minerals may be solid or migratory substances, right? They may be sold separately from the land. Owner of minerals has the implied right of entry to extract minerals. So we have the implied right of entry, but of course the state of California can reserve those rights in our title reports and say, well, you don't really have those rights, right? Ores, metal, and coal, put a star by it. Those are solid minerals. They are real property until they are excavated, and then they become personal property. So right now we're talking about what makes property real. If it's in the dirt, it's real. Once you pull it out, once you pull the diamond out of the dirt, right? Now it's personal. Does that make sense? Okay. Oil and gas, shifting or migratory substances are real property, but are incapable of absolute ownership until they are brought to the surface and placed in possession of the owner. Like Jed Clampett, right? When he was shooting at food. Up on the ground comes a bubbling crude, right? He shot at the food and then the oil came up and then he was able to capture it and then that's how he became the millionaire, right? Water and water rights, riparian rights, put a star by it. The right of the owner of land bordering a river or other watercourse, not the ocean, to its reasonable use. So I want you to remember riparian and river. Riparian and river. And they might use other words for river, like stream, creek. Think of a river as a moving water course, right? And water is moving. So riparian has to do with moving water like a river. Okay. Literal rights are the right of the owner of land bordering a sea or lake. So think of literal and lake, right? Lake water doesn't move like that unless you're like on your boat, which I'm on my boat every week, making it move. But otherwise it doesn't really move. Underground or percolating waters, the owner of land above underground water has the right in common with other owners to take his or her share for beneficial use. Percolating waters are those which pass through the ground, not in a defined channel, and are not part of any watercourse. Appropriation, put a star by it, it's on the test. It's the power of the state to take surplus underground water for beneficial use of non-owners. On page 8, highlight Roman numeral 2 all the way down to the bottom. Anything affixed to the land, things resting upon it, buildings attached to it by roots, trees, shrubs, etc., embedded in it, walls are permanently attached to the foundation, like buildings and fixtures. So this is the deal, guys. I want you to think about this. Real property is the land. We all agree to that, right? Then it's like if there's a slab foundation resting on the land, is that real property? Yes. Slab foundation resting on the land is real property. Are the trees, roots growing into the land, is that real property?
Yes.
That's real property. Now we got our slab foundation. We're attaching beams, right, to the foundation to create walls. Does that become real property?
No.
Yes. Yeah, because it's connected to the foundation, which is resting on the land, which makes it real property. Now we're putting up our walls, right? The exterior and interior walls. Does that become real property? Yes. Now our electrical system is in, our water system is in, right? Lights are going in. Are those real property? No. Yes, they are. Is the ceiling fan attached to the ceiling real property?
Yes.
Is the ceiling fan in my trunk real property?
No, because it's disconnected to the house.
Right. Is the little light switchy thing real property?
Yes.
Even though it's only like 50 cents, is that real property?
Yeah.
Right, because it doesn't matter what the cost. All right, so let's talk about this, okay? Yes. Oh, wait, don't tell me. Leah. Leslie. Laura.
Low.
Oh.
Go back in the house.
Chelsea.
Yeah.
Thank you, Chelsea. Sorry.
What about like mobile homes?
Mobile homes on a permanent foundation? Real property.
What if they're not?
Personal property, baby.
Because it can move.
Because it can move, because it's movable. All right, so let's talk about this. Anything affixed to the land, we already talked about. Buildings, when secured to land by gravity alone, or when attached to a permanent foundation, they are real property. When removed from foundation or when placed on blocks, like a mobile home, they are considered personal property. Things attached by roots, there's two classifications. Natural growth is real property until severed. It can be sold separately apart from the land, such as an uncultivated forest of trees. So this is the deal. My girlfriend, when I lived in Wisconsin, she owned a Christmas tree farm, right? She grew the trees, right? Their family grew the trees, and then they chop them down, and then they bring them to like her house, and then we'd walk down from our house to her house and pick up our tree and like drag it up the snow to our house. Like that's how we did Christmas, okay? We didn't go like way in the forest or anything. We just went to her house and picked our tree and dragged it up the up the snow to our house. So when her family grows those trees, right? Are those real or personal property?
They're real because it's on their property.
They're real when they're attached, right? When they cut it. Now, if they sold the Christmas tree farm, what happens with those trees?
It becomes whoever bought it, right?
Well, if they grew the trees, so it depends what the contract says. But if the contract says, yeah, you get the farm, but we want our last harvest, right? Right? We want our last harvest. You can sell that because then that's considered a crop, right? All right, so implements are industrial crops. Crops produced by annual labor are real property until harvested, sold separately from the land, or mortgaged. Implements also denotes the right of the tenant farmer to harvest crops after the tenancy is ended. Fixtures, put a star by C. Anything that was originally personal property, a chattel, which is cattle, which means it's movable, right? But has been attached to the land or a building in such a manner that it becomes part of the real property. It's a thing that has been incorporated into the land, extremely difficult to classify, but here are some ways. So next to number 1, to the left of number 1, I want you to write the letter M. To the left of number 2, write A. To the left of number 3, write, oh my goodness, how do you solve a problem like Maria, right? So we have to decide how a fixture is a fixture, right? If something is actually a real property. Oh, to the left of 4, I. Somebody guessed it all the way.
What did you want on the left of 3?
Maria.
R. To the left of 1 is M. To the left of 2 is A. To the left of 3 is R. There's a pattern. And somebody, what's your name? Elizabeth, the genius over here, discovered our pattern. To the left of 4 is I. And to the left of 5 is A. It kind of matches those letters, right? So this is how we determine if something is real property or not in real estate. M stands for the manner of attachment, the degree of permanence based on attachment, cement, bolts, nails, or screws. If you use one of those, like, I don't know, those 3M stickum things, is that a permanent way of attaching something? No! If you have something hanging on that, is that permanent? No. Is that a fixture? No, that's personal property. You have to take it with you, right? Adaptability. Can it be moved and used elsewhere, or was it custom made? So a regular old everyday refrigerator, is that personal property or real property? It is. But let's say it's built in and it's a Viking refrigerator. Is that personal or real property?
Real property.
Because it's built
Into the
in,
house.
right? It's built in the house. Or if it has like let's say, you have cabinetry and you have hickory cabinets all the way across, and the front of your refrigerator also is a hickory cabinet. Is that real or personal property? It's real. It was built to go with the other cabinets. It wasn't built to sell and put in a different house. Right? That makes it real property. The relationship of the parties. Between buyer and seller, the law favors buyer. Between landlord and tenant, the law favors the tenant. Right? I, the intention of the parties. Was it attached with the intention of making it permanent, or was it attached with the intention of making it not permanent? Right? So in your example, Chelsea, on the mobile home, one example on the test might be there's a mobile home on a permanent foundation with a refrigerator that has matching hickory like all the other cabinets in the mobile home. Is that real or personal property? Real. If we took that mobile home and put it on blocks, is that refrigerator real or personal property? You guys are geniuses already. I'm so proud of you. All right. Trade fixtures. Now the one caveat is the trade. Oh, by the way, in Maria, is there a C?
No.
No. So cost does not determine if something's a fixture or not. It could be a 2-cent item. It could be $1 million item. Cost does not determine it, right? Time. T. Is time, T and time in Maria. We're not spelling Marcia or Martian or anything like that, right? T is, so time of attachment. If I just put it up yesterday, does it make it any less of a fixture? That ceiling fan, I just installed that yesterday. I wasn't planning on selling the house. Well, you better take it down now and put up the piece of yucky one that you're going to sell, you want to take it with you. Because the time of attachment doesn't matter. Once you attach that ceiling fan on the wall and you took it out of your garage and you put it on your ceiling, it's a fixture. Does that make sense?
Yes.
So when you're selling real estate, this is just, every once in a while I'm going to throw things in there. So when you're selling real estate and you go into like a little 1950s house that's like worth like $150,000, $200,000, right? And they have like this ornate chandelier. Are you going to ask them, is the chandelier going with the house? No. You want to ask them, right? Because that was maybe a gift for their wedding or something. They are not thinking about it. In their mind, that's an heirloom. In our mind, that's a fixture, right? And this is going to be litigated, right? And when the buyer buys the house and the chandelier is missing, who is the boss? Who's the judge going to go with? The buyer, right? Because the law favors the buyer, right? I've been to houses where they have beautiful backyards, and you walk around and oh my God, you have the most amazing garden. Yeah. We planted that lilac bush when we got married. And that rose bush, well, we planted that when Grandma Laura died, and we planted that, jasmine bush when our friend Jasmine died. And oh, that beautiful flower over there, oh, we had a little cat named Fluffy. We planted that when Fluffy died. And all of a sudden it's like, oh shoot, all of her plants are memorials, right? You're going to leave the plants with the property, right? Oh no, we can't leave Fluffy behind, right? I had a client, like these are true stories. Like when I tell you my stories, this is real life stuff. I might give it a little fancier name or something or put little voices with it, but these are true stories. So this guy literally wanted to take the plants. I'm like, but what made the yard beautiful was the plants. I'm like, okay, you know what? I always tell them, do me a favor, before you start selling the house, dig out the plants, put them in pots. Because a potted plant, like a plant in a pot, is that personal or real? It's personal. They can take it with them, right? So they can take that plant with them. So I tell them to do that. I'm going to tell you, after they dig out the first plant, they're like, we'll leave Fluffy behind. Huh? Yes.
So say they say yes, they're taking the fixture, you just tell them to replace it?
Yeah. Take it down now and replace it with something that's going to stay there.
Before you start showing.
Because if you're going to put the $5 Home Depot one, and you have this ornate chandelier, it's going to change the feeling of the house, definitely, right? So, that being said, right, on the test, there's a kind of a weird question, and it's like it's a tenant in an agricultural property, right? And it says he's moving out. And it says something like, these are just like ideas from different students that have taken different tests, but like it says something like, is he allowed to take the ceiling fan? No. Is he allowed to take the grapes?
Yeah.
No. Because the plants are attached. Is he allowed to take the grapevines? No. Is he allowed to take the chicken coop that was strapped to the chain link fence?
No, because it's strapped to the house.
Who's saying yes and who's saying no?
I'm saying yes, no. I'm saying no because it's attached.
Well, it was not.
But how is he attached?
To the house. To the fence, no.
But he can take it away.
Huh?
Oh wait, that's a no.
He can take that.
A strap is not a permanent method of attachment. It's sort of like,
The Velcro. Whatever.
yeah, it's a Velcro. A strap is not a permanent attached way to attach something. So think about that. How is it attached is a big important thing. Okay? This is one of the most litigated things. Is this personal or real property?
Personal.
Why is it personal?
Because GS, what's that?
Unless they built something or.
But that bracket in the back
It's attached to the wall.
it's screwed in hard. Some people will argue that the TV itself is movable and the bracket needs to stay. Other people would argue saying, but that bracket is built for this size TV, not the little TV that I have, right? So these are things that you'd want to mention in a contract, right? Because you'd want to make sure you agree on it before you even, because the agreement of the parties is obviously the most important.
You're
Right?
asking, tries to give him the TV.
Right? All right. All right, trade pictures are a little different. Put a star by it. Trade figures are articles installed by a tenant for the purpose of trade, manufacture, ornament, or domestic use, and they can be removed if done without damage to the premises, and the article has not become an integral part of the premises. So pretend this is a boutique, right? I'm renting this space and it's a boutique. I know some of you are bad parents. I know it. And if I don't attach my garment racks well and cement those things to the wall, your kids are going to hang on them and pretend that they're jungle gyms, and they're not, but you're going to let them go crazy wild while you're trying on my clothes, right? And they're going to hang on that, and I got to attach them well, or that kid's going to kill himself, and I'm going to attach awesome lighting, like major awesome lighting to the ceilings, and I'm going to shine it on my mannequins and shine it on my jewelry, right? Do I get to take those things with me when I leave? No. Yes, I do, because this is my business. My business is a boutique, and my lighting shines on the things to help sell my stuff. I get to take it with as long as I patch the holes and all the stuff, but that is my stuff. So I don't have to pay for it. I don't have to make an extra agreement. It's mine. I get to take it. It's a trade fixture. So please understand the difference between a fixture and a trade fixture. Okay? That which is incidental or appurtenant, a right that can be used with the land for its benefit, such rights run with the land, put stars by A, B, and C. A, easements, the right in the land of another, such as the right to drive over another's land. B, water rights. C, share a stock in a mutual water company. The next page is an example of a residential month-to-month lease agreement. There's several pages of that. And quiz 1.